Yes.
My Lords, my Lady, as the court's aware, this case has quite a history, not just in this country, but elsewhere, and in particular in Russia, where the parties lived for their entire married life. And the history of all the litigation and elsewhere is helpfully and succinctly set out between paragraphs 15 and 17 of the Supreme Court's judgment. That's Court Bundle 261, the court's reference.
Yes.
And more detail of the blizzard of litigation in Russia can be found at page 121 of the core bundle. And there is a chronology of the English proceedings at core bundle 308 and of the foreign proceedings at core bundle 311. And Mr. Justice Cohen dealt succinctly with the various different Russian proceedings and summarized what had happened elsewhere. And I don't think there's any quarrel with his summary of those proceedings. So the parties married in 1983 and had 3 children. The youngest, Vasily, who is nearly 10 years younger than his siblings, is now 26. He's been born on the 28th of October 1998. The Russian courts determined that the parties had separated in 2007, and the divorce took place in 2014, now more than 10 years ago. And in summary, set out in more detail as I've indicated, the Russian proceedings included 43 hearings, including visits to the Supreme Court 5 times and to the Constitutional Court. And the litigation went on for just short of 5 years. The wife did not restrict her litigation to Russia. There were applications in 6 different states in America and in Cyprus, and the relevant courts all declined jurisdiction. And by the time the wife had finished litigating in Russia, she had received on the husband's case $84 million from her husband, plus child maintenance for Vasily, or the equivalent of $7.3 million. She says, as the court will be aware, that the 84 million should be $41.5 million, depending on when you take the exchange rate. She eventually turned her attention to the United Kingdom, and after consulting lawyers in February 2004, she applied for and obtained an investor visa. And later, in 2014, when incidentally Vasily was 16 at that stage, and a child maintenance order had been made in the Russian proceedings in that year, she then purchased this flat in Osprey Road. Her case before Mr. Justice Cohen was that she regarded London as her home as from 2017, and she applied for permission to commence proceedings under Part 3 of the Act on the 8th of October 2018. That's more than 10 years after the separation. In order to establish jurisdiction in this country, she needed to be habitually resident for 1 year, ending with her application for leave. As the judge held, there was no evidence before 2015/2016 that she'd spent any significant time in England. The respondent, the husband, has a new family. He bears his former wife, no ill will, but profoundly wishes that these proceedings would come to an end. And insofar as possible, he can resume his relationship with their children. If this appeal succeeds, he will have to endure further prolonged litigation in our courts. And it is worth standing back for a moment, we submit, and considering what the 1984 Act was all about. And I wonder if I might take you briefly to the working paper. This is Authorities Bundle, Volume 3, page 799.
Sorry, can you say the page again?
It's 799, my
Thank you.
As the court may be aware, there were problems that the working paper discussed about how to reform and how to provide for what was a particular problem, which they explain in a passage I will take you to. But there were, of course, always forum non conveniens arguments that were available in certain circumstances. But, they say at paragraph 22, that's at page 799 of the working paper. The working paper was immediately followed by a Law Commission report. We don't think that the limited and partial remedies are adequate, in particular for the reasons we've given above. We do not think the problem would be left to be solved by reciprocal enforcement of foreign maintenance orders. It's thus our view that in some circumstances the court in England should have power to make a financial order in favour of performance spouse whose marriage has been terminated by a foreign decree. However, we have found considerable difficulty in defining in precisely what circumstances such a power should be exercisable. In our view, the advantage of giving a remedy needs to be very carefully balanced, not only against the risks of forum shopping, that is, the risk that litigants with little or no real connection with this country would start proceedings here solely because they would be likely to find it financially advantageous to do so, but also against the related risk, which confer such a power on the courts, but in the absence of any clear guidance on what the law should apply to incidents of a particular marriage, pose problems which it would be difficult, if not impossible, for them to resolve. That, in a nutshell, was the problem. If we turn, Lord, my lady, to page 823 of the working paper, they had discussed various options that might solve the problem or address the problem in a passage that is highlighted, I hope, in the court's bundle, under the heading, a general discretion with guidelines. And it's a general discretion with guidelines, notice. Having rejected proposals for a rigid bar on applications, we are left with the alternative of a flexible discretion, under which, although an application could be presented by any person able to satisfy the jurisdictional test that we have recommended, such applications will be the subject of preliminary scrutiny by the court, which only allow the applicant to proceed if in the circumstances it was thought appropriate to do so. In the general formulation of the proposed discretion, we think that it should be made clear by express statutory provision that the object of the discretion is to provide for the occasional hard case. We consider, therefore, the court should be given power to entertain an application for a financial provision or property adjustment order, notwithstanding the existence of a valid foreign divorce, if in the light of all the circumstances of the case would otherwise be one where serious injustice might arise. Our present inclination is not to favour any requirement the applicant must be able to establish the facts to be exceptional, since he may well belong to a religious or ethnic group in which it's not uncommon, for example, for the wife to be divorced abroad. But we consider that specific guidelines should be formulated to assist the court in its discretion. And they then recommend, and I won't read out all the factors that they think should be taken into account, which goes on over the page 825 and 826, broadly speaking reflected in the statute when it eventually became law.
There isn't anything that encapsulates as such the reference to occasional hard cases there. So, I mean, you always have to be very careful with documents of this kind as to, I'm not sure if you're saying it's an construction in some way, but I haven't read anything in section 16 that talks about occasional hard cases.
I accept, of course, this is a working paper. It's not the statute, and what the statute says is what governs the approach of a court in this country to the filter, which is set up by section 13 and by section 16. But I thought it would be useful at least to see the genesis of the Act. And in fact, for example, the section 16 added certain matters to the original draft. So it isn't by any means, I'm not suggesting this is the final answer, but it gives an idea as to why there was a problem. And the problem was very much dealing with people of nothing like the means that we're talking about. Those who lived in this country, perhaps originally they'd come from abroad, they lived in this country, had a marriage, children, and then went abroad, got a divorce, came back and said, we don't have to provide any maintenance or any support to our children because the divorce was abroad and the courts have got no jurisdiction. that was what was described as the paradigm case, and as it's referred to in the course of the discussion. Not this sort of case.
No, and also, I mean, the authorities after the legislation came into force, you know, there were quite a number considering: do you need hardship? Is it, you know, there was a debate continuing as to the approach the court should take, and that was resolved in Agbaji.
It was, and the passages in Agbaji, I think the court's fairly familiar with, and indeed there are particular passages which Mr. Justice Cohen referred to and highlighted, which we see.
All I'm saying is there was quite a lot of debate after
Yes.
1984 in the cases. Do you need to establish hardship? What's the, you know? And I think, picking up my lady's point, well, maybe I can't now remember directly that reference had been made to this working paper in the occasional hard case reference, which is a reference back to what had been said in previous cases.
It's certainly not the first time that this working paper has been referred to in litigation.
Yeah.
And indeed as an aid to courts to try and make sense of the legislation. But I do accept my lady's point that ultimately one has to look at what the statute says and any guidance that the courts have given thereafter. But it is, of course, a discretion. And which we go on to discuss up to page 827.
Yes.
The paradigm case is often described as the Ruritanian case. And on the question of this, can I read at page 857 one paragraph?
857.
857 of the, this is the Law Commission itself.
Okay, yeah.
And 856, there is the paradigm case, although they say it's to some extent an exaggerated case, and it's the Ruritanian case. I won't read it out, but it gives an example of, as it were, where it almost cries out for a remedy, nothing like this. And then in the passage over the page at 857, we're talking about hardship. Serious though this hardship is, there are formidable problems in formulating satisfactory proposals for reform. The advantage of giving a person who has been divorced abroad a right to apply to the English court for financial relief has to be balanced against two different kinds of risk. First, to confer such a power would, in the absence of sufficient guidance as to the principles, pose problems which it might be difficult for them to resolve. Secondly, serious injustice might be caused to persons who reasonably assumed that the financial consequences of divorce had been conclusively regulated according to the law of a foreign country, if the other party were able to reopen the matter here, all the more so if the parties had very little or no real connection with this country. Clearly, we say that's a helpful observation. The filter mechanism was then discussed, and we see it at 859, the Law Commission's document, under Part 2. And the essence of the scheme put forward in the working paper is the court should have power in appropriate cases to make orders. The most difficult aspect is to provide workable rules for ensuring the relief is confined to those cases in which it's appropriate for the English court to intervene. In the working paper, we pointed out the traditional way of ensuring that only those persons who have a sufficient connection are entitled to invoke its legal processes. But we came to the conclusion that rules wide enough to allow deserving applicants have access to the English courts would, in the absence of some further filter, permit applications be made in circumstances which might well be thought to be wholly inappropriate. So they were emphasising the importance of a filter. We therefore proposed the leave of a judge should be required for an application to be allowed to proceed, and we set out the guidelines. And then the response to the working paper led us to a view that the solution along these lines would be a satisfactory way of resolving the difficult problems considered in the working paper. We think that laying down guidelines for the exercise of the court's powers minimises the objections to the uncertainty necessarily involved in the exercise of a judicial discretion. We have given further consideration in an attempt to ensure not only that the court's powers are only exercised in appropriate cases, but also that potential respondents are adequately protected. So it's both sides, as it were, need to be considered. We believe that unless such protection is available, the mere fact of issuing proceedings could confront the respondent with an acute dilemma. He might well be satisfied that a strong defence, but it would necessarily involve him in a substantial expense if he was resident abroad. We believe it right to provide some measure of protection against the possibility of applications under the proposed legislation being used to exert improper pressure on respondents to settle in order to avoid the expense of contesting an application. So the statute itself, which actually we can find in the same physical volume, it's page 924. Of course, the court has been referred to various parts of it, but it's quite useful to see the scheme of the legislation.
Yes.
Section 13 states quite clearly leave of the court required for application for financial relief, and no application shall be made unless the leave of the court has been obtained in accordance with the rules of court, and the court shall not grant leave unless it considers there is a substantial ground for the making of an application for such an order. Section 15 is dealing with jurisdiction, and relevant to this case is Section 15b. Either of the parties to the marriage was habitually resident in England and Wales throughout the 1 year ending with the date of the application for leave. As I indicated, that's the way in which the wife here was able to establish jurisdiction of the court. We will come to this point when dealing with the maintenance regulations. We say jurisdiction is one thing, but the question of the filter mechanism and the guidelines which the courts have given is another. And Section 16 is the key section, and both the Supreme Court and Mr. Justice Cohen are at one with how you use Section 13 and 16 together to decide whether or not you go through the relevant filter before the order is made. It will be appropriate for such an order to be made. If the court is not satisfied, the court shall dismiss the application. And then it says the court shall in particular have regard to the following matters. So I suppose it could be said that they can have regard to other matters, but these we would respectfully submit almost all the matters that a court would be expected to consider. And there was a draft bill, and I can tell the court that little f, little g, little h, and little I were in fact added to the draft bill by before the matter came before Parliament. And then we have Section 15.3, which was added in circumstances by which you've already heard. I'll come back to the point when we deal with the maintenance regulations. My lords, whatever the outcome of this appeal, it's hard not to feel considerable sympathy for Mr. Justice Cohen. On the ex parte application, his instinct, in the light of the complexity of the case, was to order an inter partes hearing. He was persuaded by powerful advocacy from a learned friend, no doubt, that this was not the right thing to do. Against, it has to be said, very much his own instincts, he decided the application, the ex parte application, contrary to what Lord Legate has now described as Rule 1 for judges. It's the case that at no stage before the Court of Appeal or the Supreme Court or today have those representing ever accepted that it should have been an inter partes case claim from the outset. On the set-aside application, after the 3-day hearing, 1 day which was reading, with both sides represented by experienced solicitors and counsel, he had what he described as a much fuller picture, and he changed his mind from what was his the approach that he was invited to take ex parte. He was told at that inter partes hearing, wrongly as it now transpires, that he could only change his mind if an authority had not been brought to his attention or he had been misled. In other words, there had to be a knockout blow. Now, he decided that he had been misled, and this entitled him to consider the application de novo. He was not addressed on the basis that if he decided he was misled, he could not then consider the application de novo. There was no submission to that effect. So what he then did was to apply the statutory test for giving leave, and having considered all the matter, all the matters he had to consider, refused the application. Now, the Court of Appeal decided that he had not been misled and there had been no knockout blow. But the court did, however, say that his initial instincts were in fact the right ones, i.e. to hear the application inter partes. Presumably, if he had done, and he had not acceded to the submissions on behalf of the wife, and reached his conclusion, no doubt along the lines that he eventually did on the inter partes hearing, the appellant would have to identify some legal error in his judgment in order to even obtain permission to appeal. It is important to emphasise, we respectfully submit, the limits of what the Court of Appeal decided in this case. The Court of Appeal themselves said that they were not deciding the merits. It was in essence a procedural point. May I take the court to what Lord Leggatt said? You can find this at Core Bundle 289. Under the heading Merits of the Substantive Claim, counsel for the husband sought more generally to raise issues about the merits of the wife's claim for financial relief under Part 3, on the pretext that the Court of Appeal expressed views that various matters relied upon by the wife justified or were capable of justifying the grant of leave under Section 13. However, in fact, as counsel for the wife had pointed out, the Court of Appeal made it abundantly clear that it was expressing no view about the merits of the wife's claim. See paragraph 88 of the judgment. All that the Court of Appeal decided was that in the circumstances, whereas the Court of Appeal concluded Cohen J had not been materially misled, he was not entitled to set aside his original order, which was therefore restored. And then they go on to say, Lord Leggatt goes on to say, some of the questions mentioned in argument about when or on what basis it could be appropriate for a court in England and Wales to make an order for financial relief under Part 3, or to grant leave to pursue a claim for such relief in a case involving foreign parties whose connections with this country are slight and whose dispute has already been heavily litigated in a foreign court, appear ripe for consideration by this court. But such consideration must await a case in which the issues actually arise from the decision under appeal. So both the Court of Appeal and the Supreme Court were dealing with the procedural issue. It's therefore our submission, I hope with appropriate deference to the Court of Appeal's judgment, that it's only of limited use to examine what the Court of Appeal said, given their own acknowledgement of the limited ambit of the appeal. However, the wife insists that this court should take into account, so it is said, that there was no challenge to the Court of Appeal's findings that Mr. Justice Cohen had not been misled. It was the very first submission we made this morning. Our answer to that point is twofold. Firstly, whether or not he was misled is not of any legal significance, having regard to the Supreme Court's decision. Second, it's not right, in fact, to suggest that there was no challenge to the Court of Appeal's finding that he had been misled. May I take the court to the supplemental bundle in this case, page 195. This is an extract from the printed case before the Supreme Court. And paragraph 44 of our printed case.
Yes.
We say the focus of the Court of Appeal's judgment was narrow, and the appeal as described by Lady Justice King has been limited in scope. The judgment concentrated on what was viewed as procedural irregularities and did not expressly consider whether this was on its facts an appropriate case for leave. whilst King LJ observed allowing the appeal so the wife could proceed to make a substantive abdication under Part 3 should not be taken by either party as expression by the court of any view on the merits of the application. She nevertheless commented on whether his sums received by the wife met her needs and implied that the wife's case was taken in compromise. With the husband's case, as the wife has no case for potential for financial provision. And can I ask the court to look at paragraph 105 of our submission, which is at page 219, where we say, at page 105, it is the husband's case that the Court of Appeal were wrong to hold that Cohen J had not been objectively misled. Cohen J's decision was an exercise of the judicial discretion conferred upon him. Insofar as the Court of Appeal revisited the exercise, they appear to have contradicted their own self-denying ordinance, which was considered the process the judge adopted. We then set out at considerable length why we challenged the fact that the Court of Appeal had concluded that he could not have been misled. So therefore to suggest, and we set this out extensively between 105 and 111, to say, as my learned friend says, that we did not challenge, it is simply inaccurate. I don't think I need to read it all, the court has its reference. And the answer is the Supreme Court didn't have to decide that issue as to whether we were right, he had in fact been misled, or whether my learned friend was right and the Court of Appeal were right, because it didn't arise on their analysis of what the crucial facts were. So return to Mr. Justice Cohen's position. He is now being criticised for his conclusions on the set-aside hearing on the basis that they were tainted by his conclusion that he had been misled. The judge approached the inter-parties hearing by dividing up his approach, as the court would have seen from the judgment. Firstly, by dealing with the knockout blow test, and then determining the outcome of the application by looking at the evidence. And by this time, effectively not in dispute, and I'll make good that submission, and applying the tests provided for by sections 13 and 16. It seems that the implication of the tainting allegation, which has been pursued with some vigor today, is that he was in some way affected by the fact that he'd been persuaded against his better judgment to hear the original application ex parte, and that this somehow compromised his objectivity. Now, my lady, this is a weighty allegation to make against an experienced High Court judge. And it's not one which emerges either from the tone of the judgment, nor from the careful way in which he applied the statute to what by then were largely uncontested facts. Before turning to his judgment, which clearly lies at the heart of this appeal, I'd like to take you, if I may, to a few short passages from the judgment of Lord Legate. This case, when it went to the Supreme Court, was the first to reach the highest court in the land directly on the correct approach to the filter. The judgment of Lord Collins in Agbargi is clearly of considerable importance, but his remarks were obiter and have in any event been qualified to some extent by the Supreme Court in this case. So what is the right approach to Part 3 applications? May I take the court, please, to Core Bundle 259.
When you say right approach to Part 3, do you mean right approach to leave or substantive applications?
Well, I said that, as it were, deliberately, because the passage is Part 3 of the 1984 Act.
Sorry, which paragraph?
It's a Core Bundle 259, and it's paragraph 6 to 10. The heading is Part 3 of the 1984 Act.
Yes.
And it looks at the scheme of the legislation as a whole. It gives the court powers to grant financial remedies after an overseas divorce, can be awarded even when a financial award has already been made in a country outside. The legislative purpose as explained by this court in Agbaji, was, quote, and he quotes the passage I think your court's already seen, the alleviation of the adverse consequences of no or no adequate financial provision being made by a foreign court in a situation where there were substantial connections with England, substantial connections, I do stress that word. We submit that the appellant here is really unable to identify any legal flaw in the way that Mr. Justice Cohen applied the statute. Can I take the court to page 268?
Yes.
Now, he concludes at paragraph 39, Lord Legate. In short, where leave to apply for financial relief under Part 3 is granted on an application made without notice, as happened here, the rules of court referred to give the respondent the right to apply to have the order set aside. The exercise of that right and the court's power to set aside do not depend on showing that the court was misled at the without notice hearing. The right is a right to argue that the without notice order should be set aside because the test for granting leave under Section 13 is not met. The approach followed by the Court of Appeal, which denied the husband that right and held that the judge was powerless to set aside his earlier grant, is therefore inconsistent with the procedural rules which the court is required by statute to apply. Then when he came to the right test, that's at 283 for bundle.
Yes.
He deals with the threshold test. Learned friend Mr. Howard has already taken you to paragraph 86 and also to 87. We then have the relevant paragraph, paragraph 89, where he concludes by saying in each of these contexts, the test applied is whether the claim has a real prospect of success. That is also in substance the test which the court applies in deciding whether to give permission for a claim for judicial review to proceed to a full hearing. Ultimately, the case is there a solid or substantial case? And real prospect of success can be assessed on the basis of the material before the court at a hearing. Inter partes hearing is clearly desirable in the case of complexity.
And in 90, he says, by contrast, the more demanding test of good arguable case does not seem apposite, because that is sort of correcting the reference in paragraph 33 to
Yes.
higher than good arguable case.
It is. Although, in fact, the final sentence of Lord Collins' judgment, which is, it is perhaps best expressed by saying substantial means solid. I don't think he does in any way disagree.
What I mean, speaking for myself, what I get out of this is, I mean, it's quite difficult to. The statutory word is substantial. Solid is not always an easy word to understand. So that the Lord Legate suggests, agreed by the others, real prospect of success is a good synonym for substantial. Is that a fair way of putting it?
I think endeavouring to paraphrase what the Supreme Court said is fraught with danger. So I will simply rely on what the Supreme Court says,
right,
in that context. What is clear is that the Supreme Court were not, as I think I've made this point, expressing any view on the merits of the Weiss application one way or another. Can I go now to Mr. Justice Cohen's judgment at
yes.
4 Bundle 198? The background is helpfully set out, and as I've indicated, he gave a helpful summary of the wife's case, so there was no doubt he was aware of We see that at paragraph 11, page 199, what the wife was saying and what she really says today. Just got one observation to make about that. My learned friend picked up what is said at little 7 at the end of paragraph 11.
Yes.
Having obtained a UK investor, she purchased a property. Since at least the beginning of 2017, I've lived permanently in London, now consider London as my home. He said, well, that wasn't challenged. I don't think the husband would have been in a position to challenge anything of that sort. It's true, that's what she said. And it was what her evidence was, and the court approached that on the basis that it was her home.
I thought Mr. Howard's point was that, as Mr. Justice Cohen goes on to say, each of these assertions is roundly challenged, that was not right.
That was not one.
Yeah, that was
I think
he was wrong about that.
I think, in fairness, I'm saying that there wasn't really an issue. It was a fact.
That was a fact, and your client did not roundly challenge.
He wouldn't have known precisely what her movements were. He then summarises the 5 different cases in relation to the matrimonial assets, and it goes into her application for leave, and he deals with the question of Russian law. We're not going to go into Russian law. Suffice it to say, he gives a pretty full summary of the various different, sometimes concurrent proceedings that were going on in Russia. Learned friend seems to say, well, this is what's required of her. I think he was borrowing the exhaustion of local remedies rule, normally used in cases of state immunity. The statute doesn't say that you have to exhaust local remedies. In fact, if anything, we submit the proper construction of the statute means that if you've been litigating elsewhere, it's a factor to be taken into consideration, whether or not you grant leave. So I think the learned friend is trying to make, as it were, a virtue out of these very exhaustive proceedings. I don't think it stands the weight of his argument. In terms of approaching this case, can I just remind the court what he said at paragraph 53?
The judge.
The judge, yes.
While you're dealing with the Russian legal proceedings, the judge said at the end of paragraph 28, that this inevitably led the wife back to Article 34, which establishes it was not permissible to divide any property not owned by the spouses. So that's what he set out there. On the issue of other Russian law, did he deal with needs other than where did he deal with, if at all, the wife's legal entitlement to apply for maintenance in Russia?
I think it's common ground that he yeah, I think that's right. He said the wife accepts that she did not mount a needs-based argument.
Paragraph 41.
Of course, the sites were trained much higher.
Yes.
This is a paragraph 41. Correct?
Yes.
Yeah. So he did deal with it.
So he doesn't deal with the legal position. Okay.
No, and of course, the concept of needs, well known to this court, somewhat elusive perhaps to those who aren't regular visitors to this court, but whether needs is the same as maintenance and how the Russian courts or indeed other courts deal with it will vary considerably. 53, the misrepresentation of English law. Can I just make one point about this?
Yes.
The court will be very familiar with the concept of when parties have a particular authority placed before them, how one side will emphasise one particular paragraph and another side would say, but it must be read in the light of the subsequent paragraph, or even draw attention to other paragraphs. What Mr. Justice Cohen says very frankly is, yes, I had Agbaji before me, but he then looks at it again, no doubt having received some lengthy submissions from Mr. Bishop and read the case carefully himself, but he looked more carefully at it and was able to extract various parts from the judgment which perhaps he hadn't been fully aware of before. And what he does, in fact, is to underline, highlight a passage which he considers of particular importance. And he says, quote from paragraph 70, there will be other cases where the connection is not strong and the spouse has received adequate provision from the foreign court, then it will be not appropriate to be used simply as a tool to top up that provision to that which she would have received in an English divorce. My learned friend doesn't like the word top up, he prefers administrative addition or some other synonym. I think it's reasonably clear what that means. And then 71, to take up some of the points made in the preceding paragraphs, the proper approach simply depends on a careful application of sections 16, 17, 18 in the light of the legislative purpose, which was to the alleviation of adverse consequences of no or no adequate financial provision being made by a foreign court in a situation where there are substantial connections with England. Of course, the question of connections with England is very much a matter which is in dispute. And then in the next paragraph 72, he underlines the fact it's not the purpose to allow a spouse with some English connections to make an application to take advantage of what may well be the more generous approach in England to financial provision, particularly in the so-called big money cases. Well, that's particularly relevant in a case of this sort. In such cases, mere disparity between that award and what will be awarded on English divorce will certainly be insufficient to trigger the application of Part 3. I mean, that is very much, my learned friend says this is a grave injustice, but actually that's what he's saying. Of course, the court will not likely characterise foreign law or the order of a foreign court as unjust. But my learned friend is doing that. He's effectively saying, because the Russian courts did not award nearly as much money as she would have been able to obtain in English courts, therefore it is a grave injustice and what he describes as a lacuna. Of course, the lacuna doesn't actually appear in the statute itself. It's a gloss that's been put on it. But it ought to be read in the light of the Supreme Court's guidance as to what the right approach is. And what he says at paragraph 54, to back up my submission, is if I had been specifically asked to address those paragraphs, I would have had more particularly in mind the following: the extent of the connection of the parties, and the court will not have forgotten the fact that it's parties plural to England, whether or not W is attempting to use these proceedings as a top-up. Clearly we say that was the case. The interplay between the adequacy of the Russian award and the connection with England, and whether W has suffered injustice and or hardship. Now, I don't think, standing back from it, one would say that the award may be a small percentage, but it doesn't obviously redound with the concept of hardship in regard to the sums of money, even on the wife's estimation. And of course, when one comes to look at the difference between Russian and English law, in fact, the award to Vasily was enormous and much greater than any award that could have been made here. But that's just an example of a different approach. The learned friend that says there's no comity point, well, there is in our submission, and we make that point in our skeleton. It's borne out by what Agbaji said. Paragraph 55, I think, is important to read. I do not think that it's necessary to descend into debate about whose fault it was, whether by commission or omission, to ensure that all material matters were before the court, or how this situation came about. The fact is the court did not have before it material matters, both of fact and law. The tone of that is very much, I'm not blaming anybody, but this is what happened. He goes on to say, which I think must be the correct analysis of A and A, B or Y, the deference to the judgment that minor representations will not be enough. And what he concludes at paragraph 59 is, I am in no doubt that if I'd been given the full picture. Now, the full picture, of course, is very much what the Supreme Court say you should get. Before me, on the 25th of January 2019, so one needs to look back at 2019, because that was the moment that he was asked to give these judgment ex parte. I would not have granted W leave to make her application. I'm further satisfied, therefore, that the grant of leave was given as a result of material misleading of the court. And he says once again, however unintentional that might have been, a rather gentle comment in the circumstances. And he then, in my submission, goes on to say, it therefore follows that I shall set aside the leave granted and determine W's application afresh. Now, there's a clear break, isn't there, between his analysis of whether or not he's been misled and going on to deal with the application. He makes a comment about the knockout blow and then deals with the application for leave. And he goes on to address himself entirely consistently with what the Supreme Court said he should have done. Section 13, he acknowledges section 15 of the court's got jurisdiction. in this case, and that H has not challenged that W is habitually resident in England and Wales.
Just before you do that, if you go back to paragraph 59,
Yes.
it says, I am in no doubt that if I had had the full picture, which by obviously now saying he does have the full
Yes.
picture, I would not have granted leave. So what's he referring to as to what made it the full picture? Is it paragraph 54 or what the matters listed there? What's...
Well, there are quite a number of matters. I think if I'll deal with when I refer to our skeleton. What we submit had emerged by the time he'd seen everything. I mean, inevitably, one side will put their own case in a particular way, and another side will put it in another way. What he eventually produced was some sort of synthesis between the two.
Okay.
And I will deal with this. It is an important
Okay.
point, my Lord.
Okay.
And, we have a particular passage in our skeleton
Okay.
which I think attempts to answer that
Thank
point.
you.
But then he goes on to deal with section 13, section 15, and then applies the test. And he says at 65, the court takes section 13 and 16 in conjunction, and he does that. And he also emphasises the foot of 66. I should emphasise the consideration extends to both parties. He deals with the history of the matter, the fact that she purchased a house in mortgage-free on Long Island, worth quite a lot of money, and Maloney Friend says it has not been sold. We're not in a position to challenge that. And then she purchased a small, inverted commas, I'm not quite sure why that's in inverted commas and how small it is, but relatively speaking, perhaps it was, for approximately 2.5 million with a mortgage. And then she retained pre-existing property in Russia, although she doesn't go there very often. And he then concluded from the evidence that the connection was recent, which can't really be in dispute, and modest. The parties' connection, where the parties were born, grew up, married, lived, and divorced, was infinitely greater. And he refers to what Mr. Bishop had pointed out, that actually it was the fourth jurisdiction in which she chose to litigate. I'll leave out the next paragraphs, which should deal with the maintenance provisions.
Yes.
And then he goes on at paragraph 80 to deal with the other matters. And he does deal with those appropriately, we submit. I don't think I need to read those out. But at 85, this is a passage that a friend I think points out to, this brings me to consideration of the award that W received. I accept W's submission that what she's received is by English standards a paltry award, bearing in mind the length of the marriage and the wealth accumulated by the husband during the marriage. If there had been a resident in England and divorced in England, she would have received an award, a vastly higher sum. To that extent, I accept she has suffered hardship. Whether the award that W has received would probably not, in an English case, be likely to meet her reasonable needs defined as the way the courts in this country define them. So he's perfectly aware of that argument. But of course, he would also have been aware of the argument about comity and how one should not likely characterise jurisdiction with a different approach as being somehow inferior. Maloney Friend has made a great deal of paragraph 88. He says that this is a classic example of a spouse whose background and married life was firmly fixed in her home country, had no connection with England. Well, that must be true until she came to this country. Whether by presence of the parties or their assets or business activities, seeking after the breakdown to take advantage of a more generous approach to her claims, she's been able to achieve in her home country after the fullest possible use of its legal system. So far, there can't really be any criticism of that. What Maloney Friend doesn't like is Mr. Bishop is right to say this claim is allowed to proceed. There is effectively no limit to divorce tourism. He made this point repeatedly. Now, divorce tourism is perhaps a bit journalistic and not particularly legal, but of course, the courts will be familiar with the concept of, for example, of libel tourism, which became a particular phenomenon in the 70s and the 80s. It's simply shorthand for somebody, as it were, going to a particular jurisdiction to take advantage of the opportunities that they may give them what maybe a better way of putting it is forum shopping. And the court may remember that forum shopping was specifically identified in the passage in the working paper to which I referred you to as one of the things that the filter mechanism was supposed to stop, or at least discourage.
So we should treat this paragraph as the judge concluding that the wife in coming here was forum shopping.
Well, whether she originally came here, there's quite a lot been made of motive here. We don't know precisely her motive. Clearly, it is a fact that she came to see solicitors and then got an investor visa, stayed 12 months and brought her application. There's been no waiver of privilege. We don't know what the specialist matrimonial solicitors advised her. But supposing, my lords and my lady, for example, she had come here on a visit to see some important cultural event and had got into conversation with somebody about the unsatisfactory nature of the award she received in Russia, then had gone to see solicitors and then brought her claim. The fact that she didn't come to England initially can't really be relevant. It is a fact that she came here, consulted solicitors, got an investor visa and brought proceedings.
Sorry, go on.
What the paragraph says in the 5th line, seeking to, coming here, seeking to take advantage. That looks like a finding that she came here to take advantage of the system. Now, I don't think you're quite saying that. You're saying something different.
Well, she came here and within the minimum possible period, she established habitual residence and having consulted matrimonial solicitors and brought proceedings. That is a reasonable way of characterising it. What I am saying is that, in a sense, what her original motive coming here might not be particularly relevant. And I'm conscious that my lady asked a question of my new friend, which is that, well, motive can only be a matter which should be determined after there was evidence. But in our submission, the judge doesn't need to determine motive. He simply has the fact that after consultation, she came here. It was the 4th jurisdiction she'd been in. There'd been an enormous amount of litigation elsewhere.
But isn't that the point? He's determining a fact by drawing an inference from the points that you make. In circumstances where, if you translate this into summary judgment terms and avoiding a mini trial to summary judgment stage, on a full trial, he would be in possession of certainly a wider range of evidence, including potentially oral testimony. He might then still draw the same inference, but there would have been a full chance to put in evidence.
Well, we would submit that it really wouldn't take the matter any further exactly when she formed the intention. I mean, there could have been a waiver of privilege. We could have known precisely the circumstances and whether she came here encouraged or whether she got here and then did it. The fact is that this is a filter mechanism. It's not there to determine each and every matter as you wouldn't in ordinary summary judgment in civil proceedings. But it is there for the court to form a view really on the facts. And I say I'll come once again very briefly to what we say were clearly facts that were not in dispute. And I think it's important that we say that we're not saying that the court should accept the wife's account entirely, nor the husband's account entirely. And if there is a real dispute, it may, we don't concede that it would, but it may be necessary to consider that there should be a further hearing. But here we have somebody on facts that cannot be in dispute, who came here, brought proceedings, and the history of the matter is agreed.
Yes, but that is not what the judge, as my lady says in the first long sentence of paragraph 88. He says this is a classic example of a spouse who effectively had no connection with England, seeking to take advantage of a more generous approach. So it's I would describe it as a conclusion that she has manipulatively decided to come here for that specific purpose. She doesn't. Her connection with England and Wales is solely for that purpose. That is the conclusion that, as speaking for myself, that I understand the first sentence of paragraph 88 to be articulating. Is that not, am I misreading that sentence?
But we submit it's a characterisation of what it clearly are the facts.
But do you, I mean, what I'm first asking your help, what do you say the judge is saying in the first sentence of paragraph 88? And then you can make submissions as to whether he was or wasn't entitled to reach that inference, conclusion, finding. But it's the first, I mean, just reading it, it's manipulation, coming here for that purpose.
But I think, with great respect, my Lord's use of the word manipulation doesn't spring from the way he's described it. I mean, breaking it down, he says, it's a classic example of a spouse whose background and married life were firmly fixed in her own home country. That can't be denied. And who had no connection with England. That can't be denied. Whether by presence of the parties of their assets or business activities, that can't be denied. Seeking after the breakdown of the marriage to take advantage of what is a more generous approach to her claims. That is the whole basis of this action, and she has been able to achieve in her own home country after the fullest possible use of its legal system.
That seeking to take advantage, that is what the Act provides. Yes. That's what everybody who's making an application is doing. They're seeking to take advantage of this right that the 1984 Act gives you. So in saying it, I would have thought the judge must be attributing more to it than that, because otherwise that sentence would appear in every case as a negative. You're just making an application, you're seeking to take advantage.
Well, taking advantage, of course, is what anyone is legitimately allowed to do. That's what the filter provides, that's what the Act provides.
Exactly.
But this is a summary of paragraph 88. It's the real meat of the judgment is his analysis of section 16 when he goes through the various aspects of how he should approach given it. And this is sweeping it up, as it were. It's not a finding of fact, as it were. It's what, having gone through the relevant statutory analysis, he is able to conclude. And actually, if you break down the various comments he made, all of them are supported and not really controversial. It may be that the word divorce tourism is unnecessary, although it had been advanced to him, and he eventually decided that wasn't appropriate use of the word, that forum shopping would be another word. And of course, my Lord's quite right. That's exactly what anybody who's coming here to do and what she is seeking to do.
Well, no, that's not right. I didn't say they're coming here to do. I'm saying that when they fulfill the jurisdictional requirements, that's what the Act gives you. Saying you come here to do that is a different. It's I think my lady used the word motivation. It's motivation. It's however you want to categorize it. It's a different aspect of it.
At the least, it's potentially attributing a quality to the connection, which reduces the quality of the substance of the connection. Effectively saying, I've lived here for 3 years. The implication appears to be that if that was in some way driven by the ability to make an application under this legislation, that counts for less than a connection established for different reasons.
Well, we would say that the analysis that the judge gives earlier on in the judgment, by going through the various parts, are the meat of his judgment. And this is a summary of what he said. It doesn't purport to be a finding of fact. It's his characterization of the analysis which is performed by reference to both section 13 and section 16. It shouldn't be taken as more. If you took out the whole sentence about divorce tourists, we submit that is a perfectly fair summary of what he has in fact found by a proper application of the statutory test.
Can I just then pick up one final point about this? The sentence which goes on then, Mr. Bishop is right to say, is that in fact extracted from, that it looks as though it is indeed a finding. He says he's allowed to proceed, then there's effectively no limit to divorce tourism. Is that taken from something Mr. Bishop had written in a skeleton argument, or is it?
I'm not sure of the answer to that, but I will try and find out before we conclude as to whether it's I think it's certainly an argument.
It may have just been part of his oral argument.
It might have been a rhetorical flourish, I don't know, but it was clearly he obviously said that because otherwise the judge wouldn't have recorded him as saying it. I don't think the word divorce tourist doesn't appear in the statute. I think it has been referred to in one or two other cases rather loosely, but it's finding that somebody is a divorce tourist is not particularly helpful. The question is looking at the section 16 tests.
In fact, it's really not so much the word divorce tourism, but it's the words that immediately precede it. There is effectively no limit. So Mr. Bishop appears to have been arguing that if this claim was to be accepted, to proceed to full hearing, there wouldn't be a limit to what type of case could come before the courts. That was it. This wasn't at the margins. This was opening the floodgates, wasn't it?
Well, I suspect that there, and I will check this, so I'm not sure, but
He did say, you know, best
Yes.
visa from a foreign court, and it's just like to his
we will check precisely what he said, but I'm being instructed. It's page 74,
Before in the core
supplemental
bundle.
bundle.
In supplemental, thank you.
Paragraph 73.
So paragraph, do you say 74?
It's
Paragraph 3.
paragraph 3, which begins its VOP's case, the NLP's claim for financial provisions is wholly unmeritorious. Marriage is literally zero connection with England, parties never having spent a single day. The parties were in England together during their entire marriage. Part 3 claims manifestly should not be entertained in respect of claims whose only or principal connection with the country is the very claim itself. Such behaviour is worse than foreign shopping, exploring, creating, or to use a phrase coined by the court on the 5th of June, divorce tourism. This is an arrant abuse. Yes, page 74,
Yes.
and it's little e. The English court was misled as to the reason for NLP's connection. In truth, she came to claim it's wholly contrary to public policy to make part 3 to be used in this way. It would throw open the door for other divorce tourists and set a terrible precedent. So I think that's probably.
Sorry, just to orientate, which document is this?
This is the skeleton argument,
Uh,
which was put before Mr. Justice Cohen on the inter-parties hearing. So in answer to my lord, it was, where does this come from? And I think, I'm not quite sure it was already, but it's certainly there in writing as well.
You gave us the reference on 74 little e. What was the other reference?
So,
73 through.
73.3, thank you. Oh, yes, thank you.
The
73 paragraph
there
2.
was originally one and then he goes
I think the court originally came up with it, but he then, obviously, as one good advocates do, he fastened on what the court had said and went a little further, perhaps, in that particular paragraph. No. I mean, I think, as I say, we've said in our skeleton, we think this is a characterisation rather than a finding as such. And we do submit that it doesn't undermine the rest of the points that he addresses very thoroughly. Can I now go to our skeleton argument, and particularly to deal with the points not in dispute? It begins at core bundle 52.
Can I just ask a different point while it's in my mind? I mean, you will both have looked through all the cases under Part 3 to date. And is it fair to say that there's no decided case with facts similar to this in terms of overall wealth?
We don't think so. There are some quite large cases, the TY and XA case, which I probably time doesn't allow me to take it to it, but it was That's the decision of Mr. Justice Moore.
Yes.
It's husband and wife both living in England. Though at the time of the wife's initial applications, he was yet to relocate. It was
Yes.
planned. Young children here at school and settled here. Valuable real property here, house in Holland Park. The wife had no other home or any other property elsewhere. I don't think anything quite on this level, no.
So at the moment, the sort of, I don't want anybody to read anything into this, but the sort of the outer reaches of the application of this provision has not been tested in the courts.
No, and that observation that Lord Legate made, which I referred the court to earlier, shows that this is clearly potentially an issue for the courts to decide. It's our submission that this case is testing the limits, that Mr. Justice Cohen was thoroughly aware of that his mind was not in any way polluted, as my own friend says. He did what judges do, which is, I find one point this way, I found another point another other way. It doesn't mean that you're not capable of coming to a perfectly logical decision on point two just because you've decided point one in one particular way. We were looking at our skeleton, and we see at page 3 what we submit is the correct approach to section 13 of the 1984 Act. And I think this is quite clear. It comes from the Supreme Court, and we emphasise little c, the onus remains on the applicant. It is always for the applicant to
Sorry, wait a minute.
prove the case.
Paragraph
This
3.
is paragraph 6 of our skeleton, and it's page 53.
Oh, sorry, got it. Yes. Yes.
And this is our, I think this is
Yes.
uncontentious, but it's our summary of what the approach is,
Yes.
coming from the Supreme Court. The onus remains on the applicant to satisfy the court there is a substantial ground for making an application for financial relief. And we deal with the fact that he heard both parties, and we deal with the test. I think we also refer to more TY and XZ, paragraph 9. We also deal with discretion and evaluation. Does it matter? I think the courts will be very well aware of all the cases, whether it's Phage or G&G, about the exercise of a discretion. Our submissions are set out, I think, in reasonable detail there.
When you come to paragraph 16,
Yes.
and you say, don't carry out the balancing exercise afresh, but must ask, and then to my mind, set out an approach which applies both to discretion and to evaluation. You have to find a gap in logic or some identifiable flaw. And so that's why I said to Mr. Howard, I wasn't sure whether it really mattered whether it was. I mean, evaluation is a. I mean, if you look back at the old authorities, I don't think you saw it as frequently as you do now.
No.
So it's a sort of a new understanding, perhaps.
I think what we say here is that Lord Legate uses the two expressions we say on proper analysis interchangeably.
Yeah.
And our essential submission is this. This is, was always the intention. This was the providing of a discretion to the court. The court is very familiar with the way in which appeals against the exercise of discretion have to succeed in showing not that necessarily that the court would have come to the same conclusion. There is some identifiable flaw, and
Yes.
it's our obviously
Yes.
submission that they can't do that. So I think I could probably, the Lordships have the
Yes,
the Lord Friend,
thank
so I
you.
don't think I can expand on that.
No, no.
Ground 13, we do make the points that the judge, and this is 18A, correctly directed himself to section 13 and 16 in conjunction. We made the point that none is accorded priority, and that is perhaps an important point. He directed himself on the legislative purpose, and he also reminded himself of the so-called sliding scale approach. And then little e, the judge correctly, now seen in the light of the Supreme Court's reverse summary judgment, took the wife's alleged primary facts on their face, although he weighed in the balance factual matter presented to him, which had been omitted in the ex parte stage. And this is the next paragraph, is an important paragraph, where we set out, and this is not a rather long deferred answer to my Lord my Lord's question about what the facts were, where we set out there is in fact very little, finally, dispute now between the parties on the crucial factors. So that we have, for example, no connection with England and Wales during or after the marriage, accepts this. No significant of any connection during the marriage, accepted. The first contact after the marital breakdown appears to be to obtain advice from London divorce lawyers. That's a matter of fact.
The last sentence in that, under subparagraph C, the fact that this happened is relevant to degree of connection, whatever her motivation.
Yeah.
And you remember what my lady said about, it appears that the judge used that to diminish the quality of the wife's connection, or the party's connections with this country. And you seem to be endorsing that and saying, indeed, the fact that the wife saw a London divorce lawyers is relevant to a degree of connection.
It's relevant to a degree of connection, yes.
In what way?
Well, because the court is asked to consider what the connection is. If somebody had lived here for some considerable time, that's obviously evidence of some connection. But if someone comes here and, for whatever reason, very shortly afterwards, gets an investor visa, goes to see solicitors, and within the shortest period of time applies for a permission to proceed under Section 13, that's relevant. Is the connection because, for example, she has children at school here, or she's bought a house here? The connection between all those activities, it's relevant to that.
But that must be, to some extent at least, a forward-looking point. Oh, she's only here because she wants this award and then she'll be off. Or she's only here because of the children's schooling, to take another example, and then she'll be off. That seems to me to be what's being said here. Because if you're trying to diminish the degree of connection by reference to this, it's unlikely to be, she is going to spend the rest of her life here, but her original motivation might have had something to do with this. It's much more, she just hasn't got the requisite degree of connection, because she may well change her plans once she's got an award.
Well,
Failed to get an award.
We deal with what Lord Legate observed during the course of the argument, as my lady may have seen. That the question of looking forward, it's difficult because, of course, the court has the facts before it.
I saw.
And let's say that she decides, as she may do, that this is a wonderful country to live in. Well, we don't know quite what the future would have been, but what Lord Legate said was she was unlikely to disappear until this matter had been finalised. The first property was Russia, and after the Russian proceedings were in New York, and she also retained property. There's no dispute about that. There isn't really a sensible challenge to the conclusion that her connection was recent and modest. I mean, that is a summary of what the judge said. He used those expressions, and we submit that's of importance. We deal at paragraph 22 with the divorce tourist point. I don't think I can add to that. Can I deal with the point at paragraph 23, which is about whether this is the old law or the new law? There seems to be a slight difference of view on the sides as to whether the test post the Supreme Court puts the threshold higher or lower than it was before. We say it's this, that the test, in fact, insofar as it seemed to be including weeding out wholly unmeritorious claims, although that's now been qualified by what Lord Legate said. If anything, that's as it were, more difficult for the husband, so that the fact that we succeeded for him, now the law, as it perhaps made it slightly higher, makes this as an a fortiori case, effectively.
Sorry, you're saying it's a potentially higher test?
Yes, because he revised what Lord Collins said by, as it were, reframing it in the way that we've been through. It certainly doesn't make it easier for the wife to establish a solid case. If anything, it makes it more difficult, if anything. And so that the decision that Mr. Justice Cohen made, if he had had the definition of the Supreme Court, it's an a fortiori case.
Well, save for the fact that they've removed, because it's not thought to be appropriate episode, is the more demanding test of a good arguable case. And Lord Collins has said the threshold was higher than good arguable case. So,
Yeah.
so that's paragraph 90 of Lord Leggett. By contrast, the more demanding test does not seem to be absent.
No.
So speaking for myself, I'm not sure that I can see the new test being higher than the old test.
It may be that it's just clearer rather than higher or lower. But what he said is, in fact, he said in paragraph 89, suggests the courts have applied the test, applied the law incorrectly. But ultimately, what he means is substantial means solid. I think we're at least agreed on that. But
And real
that's what the
prospect
statute
says, yes. Yeah.
And it may be best to stay with the statute. But we say that this point really doesn't actually probably help either side very much. But it's clear that having decided in accordance with the statute, it can't be said that he was wrong, Mr. Justice Cohen was wrong in his approach. And we make the point in paragraph 24 that the wife did not meet the threshold test under Section 30. Section 30 was not solely based on his assessment of connection, but he took into account the other factors. And we list them there: the extensive litigation, the 41 or 84 million, the lack of property in England and Wales, and the enforceability and delay, but he didn't make much of either of those points. No hierarchy, I think that's accepted, but we do submit, as the conclusion of 26, that this was a Russian case, effectively, a scant connection, following 5 years of overseas litigation. And that makes it inappropriate in our submission, and the judge was absolutely right. And the purpose was to relieve, the purpose of Part 3, as we say in paragraph 27, was to relieve the adverse consequences of no financial provision where there are substantial connections with England, which there were not. So, the learned friend, I think, referred you to what the judge said when refusing leave to appeal. We remind the court of that at paragraph 35, which is Core Bundle 62. When the judge talks about the full picture of the case, I granted permission. That's exactly what a judge in our submission should have, a full picture.
Sorry, 30.
It's 34 of our.
34, sorry, misheard. Thank you.
We give this core bundle reference. It's when the judge was asked
Yes.
about permission,
Yes.
and it's a useful summary. And he says, Lord properties, the facts that were later put to me on a full inter partes basis. Exactly what Lord Leggett should be the approach, and that's what he did. So there were changes, of course, in the way that it was put in terms of the Russian proceedings. It was argued that at one stage that there couldn't be justice in the Russian courts because of the client's influence or judicial corruption. That didn't, in fact, then feature ultimately. And I don't think it's ultimately been suggested that the Russian courts, as it were, got it wrong in terms of the Russian law, although that at one stage appeared to have been the case. So that was a different view that the judge had. We deal with the connection at paragraph 41, and we say that the wife overstates her case when saying the fundamental reason refused to, it was the lack of connection. The court must consider the connection of both parties at the date of the application for leave. the question of looking forward, I think I probably dealt with that. I think it's very difficult for a court to look forward, really. But of course, the court must close its eyes to the possibilities that either may stay or may leave. But the court has to deal with the facts as they are at the time of the hearing.
At some point, you have to deal with the points I discussed with Mr. Howard at the beginning, which related to the application for fresh evidence. That I mean, the possibilities are the appeal is dismissed. The next is the appeal is allowed. If the appeal is allowed, we would then have to decide whether we decide whether or not to grant leave or send it back for a rehearing, and how the fresh evidence application or the fresh evidence fits into that. I'm not saying do it now. I'm just saying at some point you'll need to deal with that.
Yes. Well, the fresh evidence is about what's happened since.
Yes.
The application was determined at the date that it was when the evidence was before them. What's happened since is not relevant to the appeal which you're dealing with. That's our submission. And we don't dispute that she is still primarily here, although her statement deals with other matters I need to take the court to. But it's not relevant in our submission to what this court has to decide.
I understand that, but then the second stage. So you say we shouldn't look at taking into account for the purpose of deciding whether there's a flaw, a material flaw in Mr. Justice Cohen's decision. But then if we do decide there's a material flaw in his decision and we're set it aside, I emphasise the if, we then have to decide what to do. And the choices obviously are we remake the decision or we send it back for rehearing.
We're not frightened of the statement. I don't wish to look like we're alarmed at the possibility of it being reduced. We just don't think it's going to take the matter any further at this stage.
But I mean, if we were to remake the decision, then we would probably need to look at the statement.
We don't object to you looking at the statement. We would make submissions as to how far it takes you
Right.
in terms of deciding.
Well, should we, at the end, can we come back to this? And because I want your submissions on which course you would invite us to adopt, remit or decide ourselves. Thank you.
And just before you go on, we were looking at paragraph 41,
Yes.
and your pre-penultimate sentence was rather the court must consider the connection of the parties with the jurisdiction of the date of the application for leave. You then go on, that requires consideration of the present connection. Now in a case, if I may say more traditional case, the date of the application for leave and the present connection will be pretty close in time, but that is not the case now, and it brings into sharp relief what is the date for determination under section 16? Is it the date of the application, or is it the date of the hearing of the application for leave?
I don't think there's any clear answer to that, but I think it must be the date of the hearing, because it would be unrealistic to say that you have to look back at the application.
Well, and the language it's all present.
I think that's right, but I do reiterate my submission that looking at what's happened since that hearing, and there have been many years, doesn't actually affect.
But I understand from the point of view of the appeal, that is different because we're deciding whether the judge's decision was right or wrong. Yes, thank you.
I think I've really dealt with the lacuna point, and I do perhaps reiterate this, that it doesn't actually appear in the statute. It is a gloss, and we say that it isn't appropriate simply to say there's a lacuna because you would do better in this country than in Russia. I think that probably summarises it adequately.
Yes, I mean, I think what's being advanced is that, again, this is whether one might call it a developing area of the law since 1984, I don't know. But apart from AA and BB, I don't think we've been referred, wait a minute, there was another one, but there were some other cases, weren't there, when we've been referred to some cases in which the courts have considered similar situations where the domestic court did not take into account or were unable to take into account certain wealth or maybe other factors, I don't remember it. So it's And I don't think there's any, as yet, appellate court decision on whether such a case, or the manner in which such a case does fit within the statutory framework or might not, and obviously has to be linked to other cases. But I think that's what was being argued, that it raises an issue of law, which is not really, which it isn't really appropriate to decide at a summary hearing.
It's true that there is probably no appellate authority which directly deals with the point. I mean, we have obviously the Supreme Court on what the right approach is. But essentially, our submission is that the law is sufficiently clear from the statute itself, and the vesting of a discretion to the judge, who has to take into account all those factors. That of itself doesn't require clarity. The application of the statutory test to a particular set of facts will, of course, vary infinitely, and the cases you have been referred to and are in the bundle are not precisely analogous. There's some similarities. There are two recent decisions by Mr. Justice Moore and Mr. Justice Cohen, slightly different emphasis. But our essential submission is that none of them is concerned with such large sums of money, and in such a case where one party has absolutely nothing to do with this country at all, and the other party has, to use the judge's expression, a recent connection with this country, recent then, at the time of the hearing, and a modest one. You have our submission in that respect. So that, of course, it's a difficult case, but we submit that the law is capable of application and should be applied, as indeed the judge found. I'm conscious that I should get on to the maintenance regulations. Yes, I think my learned junior reminds me that really, as far as answering to my Lord's question about the evidence, if they want, if it's the court's view there should be a hearing, then obviously we should be able to put in our own evidence to contradict that if it's considered appropriate, if there's going to be further evidence on both sides. I think I may have been wrong in suggesting what the date should be the date of application.
Date of hearing.
Should be the date of hearing. Otherwise, in a sense, it could be if the hearing is many years later, it could effectively be a fresh application by the back door. That's the problem if it's 6 years later.
But yes, I'm not sure we were because it's mental gymnastics that really don't work with the wording of section 16.2, that you have to have regard, to have with England and Wales, the connection which those parties have with any other country. And then any right which has to apply. So you're looking at whether you have a right to apply.
Yes.
So it's, but sorry, just getting back to what you were saying, is that if we were to admit the fresh evidence for the purposes of redetermining the application, if the appeal were to succeed, your submission would be that the husband would need to be given an opportunity to file evidence in response. Okay.
Since it hasn't yet been admitted. It might be there's not much to say, but we should at least have the opportunity, we submit. Can I deal with the EU regulations point? I mean, it is set out in our skeleton, so I'll try not to labour this point, given that I was given friends an opportunity to reply. It's important to remember that the only judgment on this point is actually from Mr. Justice Cohen. The Court of Appeal did not consider it necessary to deal with the point, although they did receive submissions, and the Supreme Court didn't want to hear argument on the point. So this is an appeal from Cohen J.
Yes.
And it's for the wife to show that he was wrong in this construction of section 16.3 and how it fitted into the structure of the filter process. And the Court of Appeal included section 16.3 in the grant of its permission, and that's in Core Bundle 223. And of course, he did deal with the matter, Mr. Justice Cohen, which we can see at 213, core bundle. Sorry, 214.
I do 250 actually. But, well, okay. You're right. Starts at paragraph 71. Yeah, thank you.
So the relevant paragraphs are 71 to 79. And his conclusion he reaches at 79 is, in my judgment, the effect of 16.3 is to disentitle a judge from dismissing a claim by an applicant for maintenance used in the sense of a needs-based claim with a capital or even solely on the basis of absence of connection of such applicant. It would not be inconsistent to dismiss a claim if appropriate on grounds relating other than habitual residence connection of the applicant. But I must give way to W's habitual residence in this jurisdiction. May I summarise our submissions in simple terms? Section 16.3 is to do, we submit, with jurisdiction. We don't take issue with the court, with the submission, nor have we ever done, that the court has jurisdiction to consider this because of habitual residence. So jurisdiction is there anyway. She's established that by habitual residence. She has also got, there's also jurisdiction so far as her needs claim is concerned by virtue of the maintenance regulations. And our case is that jurisdiction is a necessary prerequisite for the grant of leave, but it's not sufficient if the court is not satisfied that leave ought to be given, having applied the section 16 test to the facts of the case. And that effectively is what he did and refused permission. Mr. Justice Cohen recorded White's argument as being that the effect of 16.3 is to disapply 16.1, 16.2, where there is a maintenance element. It's not quite the way it's put now, as I understand it. The wife argues that she still has a solid case on merit, but says, and this is core bundle 48, quote, it is of course still necessary to satisfy the section 13 filter. So, notwithstanding whatever the effect of the maintenance regulation is, it is accepted that there still has to be a decision on section 13. Can she get through the filter? How does she do that, we ask rhetorically? Is a court to ignore all the matters in section 16.2? Well, the Supreme Court sets out, paragraph 92, core bundle 285, the approach that a court ought to take. How is a court, we ask rhetorically, to assess the matter, whether she can go through the section 13 filter, if my learned friend is right, and that the maintenance regulation, section 16.3, means you just don't, you ignore section 16.1, section 16.
Can we just look at section 16 for a moment, if you have it there? It's headed duty of the court to consider whether England and Wales is appropriate venue for application. I mean, that venue sounds well, and it uses the word appropriate. It does sound a bit like forum, or but it uses the language of appropriate. So when would the exercise of the power under 16.1 fall foul or be inconsistent with the jurisdictional requirements of the regulation?
Well, if Mr. Justice Cohen had decided the case on the basis of forum non-conveniens, which he didn't, then the maintenance regulations would have prevented him doing so, because forum non-conveniens is not the appropriate. That's what Russo says.
Is there any? Can you think of anything else?
That, I think, is the right analysis. It's not a masterpiece of drafting, I think, as courts have said, but it's really probably arguably unnecessary to put subsection 3 in at all, because the provision of the maintenance regulation has direct effect. And we can see, we trace it in our skeleton, the genesis of its inclusion in section 16.3. But even if there was no 16.3 and it had somehow, an argument was mounted, well, this is not the right forum, it should be Russia, but that had been advanced, then my learned friends would say, no, you can't do that because of the maintenance regulation.
No,
And
I
they would be
understand,
right to say
but the words, that's why I was looking at the heading of section 16, because the heading is appropriate venue.
yes.
The appropriate venue in other language is forum non-convenience,
Yes.
you know, which is the more appropriate forum venue. So I mean, it's
Well, it's the heading of the clause. In order to give meaning to the heading, one looks, we would submit, at what the rest of the
right.
clause, the section provides.
Oh, yes, so the critical provision is subsection 1.
I'm sorry, I'm terribly sorry.
The critical provision is subsection 1. You have to decide whether it's appropriate for an order to be made in this jurisdiction. If it's not, the court shall dismiss. Doesn't the same point that my lord is making apply to the substantive provision in subsection 1? What is the appropriate forum?
Well, it is also, Julia reminds me that Agbaji says it's not a forum non-convenience test during the course of Lord Collins' analysis. So although I do accept that the it just means you should entertain an application, it doesn't actually mean that they're wanting to put a forum non-convenience test, although I agree that the most appropriate venue does have certain connotations, I don't deny that. But it can't be that you ignore in our submission all those factors which are not to do with jurisdiction. They are to do with whether it's not appropriate. I mean,
Sorry, so you're endorsing the judge's approach, are you?
well, yes, we partly do that. We have two arguments, as I think the court's aware. We have one, we say either the judge was right and you shouldn't interfere with it. Alternatively, our other construction, and I'll come to that if I may. Yes. I'm grateful in Agbaji, it says, and this is paragraph 49 of the judgment, section 16 does not propose a statutory forum non-convenience test. It does not require the court to determine the only appropriate forum where the case may be tried more suitably, the interests of the parties and the ends of justice. So that's an answer from the Supreme Court file.
49.
49. Yes. Yes. We submit that that section 16 in fact plays a dual role. It's going to have a role at the leave stage and also have a role at the final stage if there is one. But it can't be, and I think this was a question that my lady asked my learned friend, you know, how is a court, if it has to go through, and it's conceded, it has to go through the section 13 test, how does it do it? If it ignores section 16.2, which is what their argument is. I'm afraid I didn't understand what the answer to that question was. It has to be a solid case. How do you assess what a solid case is? Parliament has actually laid down how you assess that, and that must be, in our submission, the answer. Our skeleton on this point can be found at page 70 of the core bundle, paragraph 65. And going back to the origins of this particular filter, forum non-convenience was expressly considered by the Law Commission and the Working Party as one possible way of dealing with these difficult cases, and it was rejected in favour of this discretion provided by section 13 and 16. We refer to the discussion at paragraphs 84 and 85. So we submit that it's still necessary, and this is paragraph 68, for a prospective applicant to satisfy the section 13 filter of having a solid case on merits, and we say can only do that by looking at section 16. We set out at paragraph 70 onwards the legislative background section.
Yes, thank you.
63,
Yes,
which I hope is helpful. It's
Yes.
probably not something that admits of much elaboration
No,
orally,
no,
but we do think it's important to stress the genesis of it, and particular when you get to the final answer. I mean, this was really, in a sense, the belt and braces provision on jurisdiction. If we go to paragraph 74, we see how after the consultation, it was all done in a bit of a hurry, as I think other courts have observed. It was amended to read, and then we put the part in black at top of page 73, if to do so be inconsistent with the jurisdictional requirements of that regulation of that schedule. So it was expanded expressly to include that wording in bold, and it could not have been intended to render the leave filter redundant. Otherwise, it wouldn't have been included in the draftsman. And we can see there's a specific reference to Uwuzu.
Yes.
And that's a very much part of our case. It had been decided in 2005. Agbaji in 2010, which, as I reminded the Lordship, was decided that forum non-convenience is not the test. They were made to ensure consistency with the European regulations and to stop arguments about forum non-convenience. And that's why I said if Mr. Justice Cohen had concluded on that basis, he would have been wrong, but he didn't. We accept that. He quite rightly refused leave at all to make a claim by taking into account all the section 16(2) matters. And we dealt with Cohen J's decision on the interpretation of section 16(3) at paragraph 80. And we deal at paragraph 82 with the additional reasons. I indicated there were two reasons, two bases, and we had an amended response to the appeal by reference to the Law Commission, an additional filter, and we give reference to the working paper in footnotes, and we also have agreed between learned friends that the reference by Lord Legate to maintenance creditor is not right.
no.
And in fact, a first-time applicant
it couldn't
qualifies. Even Homer nods.
Yeah.
So that was the position. And so section 13 are not dealing with jurisdiction, and the additional factor in section 16(3) added is simply to make sure that you don't turn down jurisdiction on the basis if there is in fact a maintenance provision. So, in other words, those are our submissions on the EU regulations point. I've taken them briefly because I think they are set out with some detail in the skeleton argument. And I'll just conclude by trying to answer what my learned friend completed his arguments with. He said that you had to assume my client was right on the factual assertions that she made. Well, our answer to that is a court has to look at we now know, on what both sides produce. And clearly, if there's something fiercely contested, then that may or may be difficult to do. But the history of looking at what used to be known as Order 14 cases, when both parties put in summaries of what their different their arguments were, it's very often possible to distill what is uncontested, which is what our submission makes good, and make a decision on the basis of what is uncontested. And that is largely what happened here, and when this judge came to the conclusion that he did. Learned friend says you have to take the wife's assertions, even where they disagreed with, as if they are the only account that matters. He says you must look forward to the trial. I think you have our submissions on that, and you have our submissions on the question of the appropriate test, which the Supreme Court has now, I think, made reasonably clear, at least. But what the judge did here was to do what he probably should have done right from the start and wanted to do. Looked at the case in the round, directed himself in accordance with the statute, and the learned friend is struggling to find any fault in his analysis of the statute. So he says that the judge is somehow tainted in his approach because he found, as he did, on what was in fact, in retrospect, an unnecessary finding. We submit he was not, and it's quite clear from the way that he summarised the case that he was being extremely judicial in his approach to this case. As to the divorce tourist case, well, maybe that's not the right way to describe it, but we don't need that finding. The rest of the findings are quite sufficient to justify his decision. But it's not us who has to justify the decision. It is for my learned friends to say that he was wrong, that he exceeded the discretion which had always been the intention of the legislation. He had a discretion, he exercised it appropriately, and our submission is that this court should not interfere with it.
So can I come back to the, if we allow the appeal and set aside his decision, whether we redecide the leave application, redetermine it rather, or whether we remit that for determination below.
Would your lordship allow me to take instructions on that point?
Of course. Do you want 5 minutes? Because it's quite hot in here. Why don't we take 5
Extremely
minutes?
hot. That's fine, I have 5 minutes.
Let you know the live streams will remain on.
so if that's not.
Can't say that anymore.
You're not allowed to say it, I don't think so.
I
no.
think you're allowed to say it.
Are you? It's terrible, isn't it?
This is why they haven't got air conditioning.
It's a reflection on the state of our country.
Yes.
Both the curtains and the heat.
You go to some other courts,
The Royals building.
they're completely falling apart. Millions. Tantamount to a fresh application. 650.
At least. Fresh application. My was she hasn't made.
We got what, 70 million plus.
That's where the canon
70
was wrong.
75.
The judge is wrong or right.
It was part 3, wasn't it? Yeah.
Sorry, I just don't think we should concede.
You're still going to have plenty of time for your reply. Sorry? You're having plenty of time for your reply in accordance with our agreement, I think.
Yeah.
Thank you. But it shows we can do a day. I have to say I was a bit dismayed yesterday. It just means you haven't got time to go into cases.
Yes.
Although I'm grateful for that opportunity to consider the matter. It's well, of course, our fundamental submission is that this appeal ought to be dismissed.
It's if. Don't worry, we've got that.
I don't wish to, as it were, resile from that.
No, you're not. You're not.
And we also, perhaps, in one sentence, analysing it, apart from the fact that all litigation, we say, must come to an end. There is a public policy element in it. And this seems destined, perhaps not to. As far as whether it should be, if your lordships are against me, and the ladyship against me, we submit that it would be better to be remitted to a judge. If the court may want to give guidance as to what is appropriate, one of the things we would submit is appropriate is to say that we should have the opportunity to respond to the statement if so advised. And secondly, we would ask the court to give guidance.
When you say respond to the statement, you mean the
Written
latest
statement that's not yet been admitted.
If we admit it.
If you admit
Yeah.
it, yes. There are quite a few hypotheticals here, but
Yeah, no.
I hope that's clear.
Guidance on.
Guidance on this matter. The question is, what is the date to be taken for the purposes of an assessment of whether or not the wife can pass through the Section 13 filter? We submit that it should either be the
I'm
date
smiling because we haven't exactly had extensive submissions on that issue. If you're inviting us to give guidance on it.
well, there haven't been extensive submissions.
No,
It wasn't something that was easily anticipated
Yeah.
coming up to this hearing. But the problem is if, for example, a judge has to consider this matter in 2 years' time, say, then of course it's a different factual scenario, or maybe a different factual scenario than one that Mr. Justice Cohen considered in 2019. It would effectively be a fresh application, and we respectfully submit that it wouldn't be appropriate. And
When you say the application, you mean for leave or substantive?
well, it's for leave,
Okay.
yes. If your lordship is going to
Because on the substantive application, you would undoubtedly take into
Yes.
account the facts as they were at the date of the hearing.
that's true, but I was assuming that it was going to be remitting.
So
leave.
for the purposes of leave, your submission would be that you take into account, you look at the facts at a different time from from the date at which you would be looking at them for the purposes of the substantive application.
Yes.
But the leave application is deciding whether or not, putting it loosely, looking at the merits of the substantive application. So you have got me in a complete intellectual twist as to how I do both.
Yes,
Anyway, that's your submission.
it is not a submission.
Okay.
Yes.
So you would say why better to remit than us to, why a further hearing rather than, because it's on paper, there's not going to be any evidence. Why remit rather than us determine it?
Sorry, excuse me. Of course, that it will be determined partly what your lordship's and the court's view is on admission of evidence.
Yeah. Okay. Yes. Yes. I understand that.
So we haven't
Okay.
had a decision on that matter.
Okay. Thank you. Anything else? No. Nobody following? No. No. Yes, Mr. Howard.
The first point was that my learned friend, in dealing with the background, said that the connection started in 2017. That is not what my client said. Could I ask you to look at Supplemental Bundle 302? This was a reference I gave you.
(302).
302. Paragraphs 98 and 99. Intended to live permanently in England since 2014 when I applied for an investor visa, and my life has been entirely focused on London since 2016. Once my mother is deceased, I will have no reason to return to Russia. And then she deals with her immigration status, which of course is something that might be updated. So really we say, if you apply, that is not contradicted, those two paragraphs, if you base any decision on that, her connection with England was not modest, nor was it particularly recent. It goes back 5 years until the decision. Secondly, another disputed fact, my client does not accept that the separation occurred in 2007, and that is a matter for the final hearing. Thirdly, the US proceedings were for discovery. They were not substantive, and the US courts, as far as I understand it, did not decline jurisdiction. My learned friend then went on with the working paper, and he took you to page 824, and of course that paragraph, we no need to turn it up, referred to cases with a serious injustice, which of course is what we rely on. He also paid lip service to the fact that section 16 was not exhaustive on the factors, but that is confirmed in Agbargi at page 99 of the authorities bundle.
Sorry. What?
Page 99 of the authorities bundle.
Yes.
about it be, though also, because the list in section 16.2 is not exhaustive, the court shall in particular have regard, matters which are not expressly referred to, such as hardship or injustice, may be taken into account for the purposes of determining whether it's appropriate the English court should make an order, just as they can be taken into account under section 18. So clearly injustice is a factor which comes within section section 16 and 18, and therefore the leave application. My learned friend took you to section 13, but of course one mustn't forget the subsection of section 13, which is to the effect that the fact there's an order in the foreign court does not preclude a second order. Then it was said to rely upon what the Court of Appeal said on the last occasion, that the court expressed no view on the merits, but it did express a view on the merits of being misled. What it didn't express was a view on the ultimate merits, which is different. And that is quite clear from what Lady Justice King said at page 247. It's paragraph 88, the second line, where she said, it is therefore unnecessary to consider whether, sorry, about 6 lines down. The fact that the appeal has been allowed and that the wife may therefore proceed to make an application for financial relief should not be taken by either party as an expression by this court of any view as to the merits or otherwise of that application. It's the ultimate merits, not the merits in relation to being misled. Lady Justice King was absolutely clear that she was expressing a view, and the other 2 members, including your lordship, agreed on misleading. And it is right that in the Supreme Court there was no challenge to the finding that the court had not been misled. It wasn't a subject of the appeal, and it was not one of the grounds of appeal. And if necessary, if your lordships and your ladyship require, we can of course provide the husband's application for permission to appeal. It was not included. So the Court of Appeal's conclusions on the last occasion about Mr. Justice Cohen not being misled stand. Top up. It's not that I don't like the concept of top up. I say it is inapplicable here, and we deal with that in paragraph 80 of our skeleton argument. And it is really what it means. That was what we were alighting on. It means equating the award identically to an English award. And it is obviously all related to generosity and disparity. That is not our case. But Mr. Justice Cohen clearly went along that route by saying it was paltry, which refers obviously to generosity. My next point, paragraph 59, your lordship, my Lord Justice Moylan asked my learned friend about this, paragraph 59, which we heavily rely on, and he came back to it. And he said the answer to that observation is paragraph 19 of their skeleton argument, which is at C58. And if you look at C58, paragraph 19, those factors, there's nothing new. Nothing new at all after Mr. Justice Cohen's ex parte application. The only thing that's new is the impermissible reference to the visit to the solicitor. But everything else was in my client's witness statement. And then my learned friend said, well, a different view was put on the corruption allegation. Well, again, that is not right, because before Mr. Justice Cohen, and this was dealt with by Lady Justice King, when I applied ex parte for leave, I did not rely on corruption. I put my case on lacuna an injustice. Then my learned friend dealt with paragraph 88 of the of the decision, which is at 217. And of course, I reiterate that this is the key paragraph on sharing. And we say that it isn't a fair summary of the rest of the background because it is all historical. All my learned friend said, well, divorced tourist is synonymous with forum shopper. Well, it's the same point. And he then said, well, that it came from Mr. Bishop. It didn't actually, as I pointed out in the references S Supplemental Bundle 73, it was the judge who coined the expression. And what my learned friend is driven back to is to, again, reliance on the visit to the solicitors. He actually said to the court, there could have been a waiver of privilege. That is quite impermissibly seeking to draw inferences which Lady Justice King dealt with. As far as where divorce tourism came from, in addition to the references that my learned friend gave, there is another reference at Supplemental Bundle 111, paragraph 145, but it comes to the same thing. Your Lordship then asked whether there was a Part 3 big money case. There is the case of Jafali, which we mentioned in our skeleton argument, which in fact I, together with my learned friend Mr. Nagpal, were in. Now, Jafali was a case in which the wife got a needs award in the region of between 70 and 80 million, which is a fairly big money case. It was never ascertained quite what Mr. Jafali, perhaps he wasn't called Jafali, the husband was worth, but it was certainly in excess of 650 million. It could have been a lot more. Then...
That was Saudi Arabia, was it?
Saudi Arabia. Though the wife was not Saudi Arabia. And then there was speculation as to whether there was any Court of Appeal higher court guidance. Well, there is Agbarji itself, of course. And we say Agbarji was a lacuna case, because what the Nigerian court could not do was make a transfer of property order and seemed to think it couldn't deal with the English property. And if your Lordship, the court remembers, what the Nigerian court did was they gave the wife, who was living in England in a property, a share in a property in Nigeria, which was, I think, called in Tin Can Alley or something like that. And of course, what she said is, I want the London property. And that was a lacuna. And the Lord Collins had no difficulty upholding Mr. Justice Coleridge, who made an order in relation to that property. As the remission stroke new evidence point, well, we say that this case should not be remitted. It is an assessment on the paper. This court knows now much more about it than any first instance judge will. It will be enormously expensive, and one has to consider the delay and the expense. It is quite clear that this husband has spent millions and millions on this litigation. We think in the region of 7 or 8 million. There is a difference. My client has spent a lot of money, not nearly as much as that, but really we should look at economy. We should also look at delay. Lord Collins and Agbarji said the delay in that case of 2.5 years was shocking. Well, this is trebly shocking because it's now, since the application, it is nearly 9 years. It really needs to get on with it. As far as further evidence is concerned, our new evidence just, sorry?
7.
I can't add up. 7. I'm sorry.
You already confessed to that, Mr. Howard, earlier on.
No, he
On
said
that
he
occasion,
said
you said you could. Yeah,
7.
yeah.
I'm sorry.
It's all right, don't worry.
It's still a very long time. And it is about 3 times. I was right then about that. Our new evidence, we've said, is on connection. My learned friend has said that the husband really can't contradict connection. Really, nothing else as new has happened in the case. It's just gone on. What needs to be updated is my client's connection, and there is no need to put in any new evidence. The final point I want to deal with is the time when. Now, what is significant is that section 16 is in contradistinction to section 15, which fixes time at the date of the leave application. Section 16 has no such limitation. And of course, no such limitation is consistent with what Lord Leggett said, you've got to look forward. It's also consistent with the present tense being used in 16A, B and C. And we deal with this in paragraph 64 of our skeleton argument. And I'm not going to repeat that. But because in section 13, you're looking at the section 16 factors, which are in the present, and Lord Leggett says look forward, you look at the present. And if it's remitted, it will be looking at the time of the consideration of the leave anew, which has to be on the basis of what is happening now and what is happening to my client as far as her connections with Russia, her connections with England, and the connections of the 3 children, which is really what the new evidence is about. That's all I want to say, mate. I think Mr. Nagpal has 2 minutes.
Oh, sorry, yes.
I have just 5 very short points in reply on the maintenance regulation. The first is there was no answer from Moylan and Friend as to why section 16.3 refers to section 16.1 and not to forum non-convenience. That's what it could have said if his construction is correct. Secondly, I think the reference to Ambargi, where Lord Collins discusses the overlap and why section 16 is not identical to forum non-convenience is paragraph 50 of Akbargi, which we'd invite you to look at, not now. But third point is it was suggested that I didn't answer the question, well, how do you do it? How do you do the leave question? And my answer is very simple, is that the court looks at section 18 and it has to make a summary judgment assessment on section 18, but it's section 16.1 that comes out.
Yes, but not section 16.2.
No, but it's...
In other words, the section, because I mean, even if you start at another section, you have to have a look at all the sections of the case.
You have to look at all the sections of the case.
And the sections of the case would include the matters set out under section 16.2.
Well, they would include all the matters,
Yeah.
including those. I do accept that, but whether that would have the impact... First of all, obviously, that's not what the judge did in this case. He said, I'm dismissing you on section 16, I'm not dismissing you on section 18. And so in that sense, he was wrong. But secondly, whether at a summary judgment threshold that would have any much impact, we would say that's a matter for trial as to where you sit on the spectrum. The fourth point is there was no answer to the fact that section 16 and forum non-convenience contain the same vice as regards the Brussels regime. The rationale for excluding one applies equally to the other. And of course, my lord was looking at the heading of section 16. We know since, I think, all that stuff in the bundle, since Lord Goff's seminal speech in Spiliard, that forum convenient should be translated as appropriate forum rather than convenient. That's been throughout the ages, that's been said. And venue, I would suggest, is an English translation for forum. So it is appropriate, duty to consider appropriate forum. Sorry, well, indeed, perhaps French, but it's obviously intended to be English venue. And so so we do say it's the same vice. And the fifth point is that there hasn't been a rival construction that makes sense. If it doesn't mean what we've suggested it means, I pose the question rhetorically, what does it mean? And nobody has been able to answer that satisfactorily. It can't mean what the judge said. And my own friend's construction, insofar as it's there, we have dealt with that in the additional, in the supplementary skeleton below, just doesn't work because you don't get to section 16 unless you've gone through section 15 first. And so the interorum argument, so it's, oh my God, forum convenience is gone. But yes, it has, but that's what the maintenance regulation did. I know it's antithetical to the instincts of a family court judge, but it doesn't mean that it's wrong. That's all I wanted to say.
Thank you very much.
Can I just say one thing? What Melanie Friend said about looking forward, the particular way that the Lord Legate expressed itself on looking forward is worth looking at. As to what he
Okay, thank you very much. I was going to say something about the impressive extent of the legal teams that are representing the parties in this case. So we need to thank everybody involved in the drafting, the creation of the submissions, as well as the oral submissions today. So thank you all very much. We will be reserving our judgments. They'll be provided to you in draft for the usual very limited purposes, correcting our grammar, and not for any other purpose. And the warning at the top of it means what it says. And if you act contrary to it, it's potentially contempt of court. We would hope that once you receive the draft, you will be able to agree a draft order, but if not, we'll deal with any outstanding matters on paper. And thank you very much for completing your submissions. I know it meant that you had to deal with them at some speed, but we've had plenty of opportunity to read the papers, and I think it was sensible to complete them today, but thank you for doing that. So that concludes today's hearing. Thank you.